As North Carolina officials continue to weigh the state's approach to legalizing marijuana, lawmakers across the country are now still considering rights of legal marijuana users. So a U.S. appeals court ruled that a federal law that bars illegal drug users from owning guns could be deemed unconstitutional when applied to medical marijuana users. So the ruling comes after a group of Florida residents who then use medical marijuana claim that the law violates their rights to keep and bear arms under the Second Amendment. Let's talk about it. Chief Legal Analyst Clive Rhodes joining us now to explain the ruling. First, explain more in depth as to what we're talking about and what stands out to you with this.
When you have a firearm or attempt to purchase a firearm, you got to fill out an ATF form. That filling out of an ATF form asks you a number of questions. Are you on parole or probation? Have you ever been convicted of a crime? Have you been charged with any domestic violence charges? And this other question is, are you using drugs? At the time, are you using drugs? So that question is on ATF form 4473. That question puts people in a very weird position because the question says, are you using unlawfully use of marijuana? Right. And if you answer yes, it results in a denial. If you answer no, falsely, now you're lying on a federal application. That's a felony. So it puts you in a weird place because on the federal side, it is still classified as a Schedule I drug. But on the state side, specifically in Florida, where this case comes out of, it's legalized specifically for medical usage. And so it puts the applicant in a weird position, and the court goes through a number of analysis. But this Court of Appeals said that you should not bar them because they are using medical marijuana because it's medicinal purposes. I mean, it's just like someone using a prescription drug that isn't something historically connected with the negative effects like marijuana has been used over the time.
So it sounds like it's just a matter of putting a box on the application that says you can check this box if you're using medical marijuana, or a different wording of it is what we're looking for.
Yes and no. I mean, on the first portion, as I would agree, the application would need to be changed, but then also the classification of the drug would need to be changed. So the Trump administration is following what the Biden administration talked about in the last few years, changing the classification from Schedule I to Schedule III, or unclassifying marijuana completely would allow you then to add it on that application as not being a drug that they're checking for. But then you look at the historical impact. When you go through these types of questions, historically, and this is what the court has went through in a number of these gun right cases, historically, have we wanted people that have had some type of drug usage or drug possession or drug charges? Do we have a history in this country of not wanting them folks to possess firearms? Right. The argument the courts have said is no, we haven't. We haven't had a history. We've had a history of not wanting people that have committed felonies to not have firearms, but not folks that have used drugs. Additionally, we've had it for folks that are on domestic violence charges. Why? Because we don't want them to go back and shoot the victims or their significant other. But to this one with drug possession, drug users, there's no history behind that. And because there's no history behind it, states or even federal law that attempts to stop folks from getting access to firearms or criminalizing their ability to access it by putting this form in their way, it will be unconstitutional based on the court's reading. The Supreme Court's hit on this a couple times. This court right here is doing the same thing. So
when we talk about next steps, Khalif, after what happens here, what are some of the things that are concerns for you?
I mean, it's concerning from a number of things. I mean, I walked through the first portion. That's that test that the Supreme Court talked about in United States versus Rahim back in 2024. They went through what is the danger, the justification for allowing these folks to have access to firearms. Are they endangering themselves? Are they a danger to others? Compare marijuana to historically other folks that we've disarmed, like mental illness and drug addictions. Drug possession or drug usage and drug addictions are two different things. And so you don't want to place that barrier because the Second Amendment is something that we hold as dear and near to our hearts as a country, that you have that constitutional right to bear arms. So before you remove a person's right to do that, you want to ensure you're jumping over all of the necessary hurdles. And first is not creating new laws as a judge or a court. You don't want to do that. You don't want to create new rules and regulations that they have to jump over by your interpretation of what the law is. And so the courts have been hands off on that, specifically trying to say, if we haven't historically done it, let's not add it now.
All right. Khalif Rhodes, appreciate your insight as always. Thanks so much.
Queen City News Plus. Just search Queen City News on your smart TV's app store.